Negligence law is based on the moral attitude of a society and the behavior of the people, which is subject to change over time with the accumulation of education, cultural exchange, and historical developments. With that, we are to evaluate whether the law of tort, the part of the English common law, which has developed incrementally since Norman times, still serves a relevant purpose today. The origin of negligence can be traced back to the 14th century, when the word trespass on the case was used. It covered injury which was consequential to a wrong, but the wrong was neither forcible nor direct. The new test on whether a duty of care should arise is now laid down in Capero Industries and Dickman, which also asks if it is just and reasonable to impose a duty on the defendant. Generally, when justice and reasonableness are being specifically referred to, it is because the case meets the requirements of forcibility and proximity. But the court believes that there is a sound public policy reason for denying the claim. The breach of duty of care means that the defendant has fallen below the standard of behavior expected of someone undertaking the activity concerned. The standard of care is objective, but it is irrelevant to ask whether the defendant's conduct seems fine to himself. But it is must to meet a general standard of reasonableness. Just like the standard of a reasonable driver, the law takes no account whether the driver has been driving for 20 years or 20 minutes, as in nethership and vessel. Of course, there are other factors being considered by the court before holding the defendant in breach of a duty, which include the standard of skill required by the defendant, the magnitude of risk, and the potential benefits of the risk. Furthermore, it must be proved that the defendant's breach of duty actually caused the damage suffered by the claimant, and that the breach that caused the damage is not too remote. It is done by using the but-for test. In Barnett and Chelsea, Kensington, it was accepted that a duty of care is owed by the defendant, and that there is a breach of duty by failing to examine the claimant. But the breach did not cause his death, as even if he had been examined, it was too late for any treatment to save him. Therefore, it couldn't be said that, but for the negligence by the defendant, the claimant would not have died. The test for remoteness in negligence is reasonable foreseeability, which means that a defendant will be liable for damage which was reasonably foreseeable at the time when the defendant breached that duty. Therefore, do these elements laid down under the common law still remain relevant with the current hot topics and issues? Let's go on a ride and with this, find out whether this historical piece of instrument still able to compensate the aggrieved party or no.
Wow, new passenger! Oh, there he is!
Dave!
Oh my god, such a bad accident. Ladies and gentlemen, seeing it is a T junction and driver B was coming from his lane of right and his lane of road coming into this junction, he should be given the priority. So it's fair to say for this particular accident, driver B is out of the equation, but driver A is at fault. So today, we have to prove three things. Firstly, on the idea of duty of care. Driver A owes everybody on the road, on today's case, driver B, a duty of care. Secondly, we have to prove that there is a breach of duty. Let's look at driver A. He was extremely careless in coming out of the junction. He's not fastening his seatbelt. Lastly, he's using his phone. Let's look at the reasonable man test, for example. Would a reasonable driver be doing what driver A is doing? Absolutely no. And lastly, we have to prove causation. This can be seen in the but-for test. If it wasn't for driver A's carelessness, if it wasn't for driver A's negligence on his end, would the accident still happen? No. Who does the claimant claim from? The driver or the company of the driver?
Wait. Don't scold me, don't scold first. I am the employee of Uber, and this accident happened because I was carrying out a duty for Uber.
It's not me. Kelapa bapak kau. Kelapa, it's kepala lah. You caused this accident. We can't be held liable for your mistake. We're merely a platform. This is all you.
According to News Straits Times, June 2nd, 2017, the Grab car company told the drivers to make a personal report for their insurance claim. The company refused to bear responsibility for the damage of a driver's car obtained in an accident while on duty. A simple research on the Grab website policy on accident, and it states that a driver shall be solely responsible for all claims, judgments, and liabilities resulting from any accident, loss, or damage. So the Grab strict stance that they are not an employer and they shall not be liable, is that fair? Who is an employee? Person is said to be a servant if his employer retains a right of control, not only the work he does, but also the way which he does it as an employee. Hence, it is extremely fair to say that an e-hailing company is an employer to an e-hailing driver. The doctrine of respondeat superior is based on the employer-employee relationship. This doctrine makes the employer responsible for a lack of care on the part of an employee in relation to those to whom the employee owes a duty of care. For respondeat superior to apply, the employee's negligence must occur within the scope of her employment. It is essential for us to know whether B is an employee of A, and also to determine whether B was within the scope of employment when the negligence act was committed. Hence, the driver was in the midst of employment when the accident occurred. It's fair to say that this doctrine will be applied in this circumstance because the Grab driver was within the job scope when an accident occurred. A case that we can look at is Cox and Ministry of Justice. For us to determine vicarious liability, there are three tests that we can look at. Firstly, the control test. Secondly, organization test. And lastly is economics reality test. So in this case, it is fair for us to conclude that Uber has ability to control, hire, and fire their workers. If these factors are present in a circumstance, then vicarious liability to occur. Who does the claimant claim from? We have established to you that vicarious liability exists in this scenario, and it's fair for the company of Uber to compensate some, if not all, part of the claim. So how relevant is vicarious liability involving e-hailing company is relevant in today's day? This element of vicarious liability is extremely relevant in today's day because the number of e-hailing companies are increasing day by day. If people are not aware of what they can claim, how they can claim, from who they can claim, especially in today's scenario, then we think it's extremely relevant for us to present this idea of negligence to all of you.
Good morning, my name is Shaun Foong, and today I'll be talking about negligence involving social media. More specifically, sexual predators and whether social media companies should be held liable for it. I will be going through the basic elements of what constitutes negligence and some cases regarding my topic. Firstly, social media should not be seen as just a place to enable users to share, create, and take meaningless selfies, but rather as a public place or public transport. Over! This opens a gateway for sexual predators to practice grooming, sexual exploitations, which could lead up to a possibly bigger threat, human and sex trafficking. In the journal article of Children and the Internet, Beware from the Threats Within, page 4 states that socializing with a wrong person such as a sexual predator or a pedophile who participates in various online communities and makes attempts to initiate inappropriate relationships with these children is common. Moving forward with my next issue, I'll be talking about... Oh, what's up, Adam?
Hi man, how you doing?
I'm doing good. Please take a seat, take a seat. So what brings you here today, actually?
Yeah, you mentioned about your research, so I was very intrigued by it.
Oh yeah, it's about negligence in social media and
I have a couple of questions to ask you if you don't mind.
Oh yeah, no worries. Just ask away.
Right. The first question I have is that, are there any cases or trials that are ongoing that the claimant has tried to make the social media companies liable for their negligence?
Yes, in fact, I just read this case last night. It was about a lawsuit in Texas about a woman. She was at the age of 16 when she befriended somebody through mutual friends, and that man later went on to rape, sexually assault her and forced her into sex trafficking. So Facebook here is being sued for gross negligence in being negligent in ensuring the safety of their users.
Oh, that's actually a very, very interesting point. So when you say negligent, right,
Yeah, correct.
to their users, how do you determine negligence in this case?
Alright, this brings me back to the main equation of the existence of duty of care by the defendant, which is in this case social media, to the claimant, which are the users. They have a responsibility to care for their users with proper verification of people and tight security. And second, we move on to breach of that duty. Is there a poor breach of security, and is that considered as a breach to the duty of care? Thirdly, it would be damages caused by the defendant's breach. So in this case, it would be access to rapists and sex trafficking and pedophiles. And lastly, it would be the causation, which is the but-for test. If it was not for Facebook's breach of this duty, will this damage actually happen? This is negligence.
Oh, that's actually a very, very interesting point. So Shaun, are you trying to say that these social media companies are a platform or more than a platform for people to use them?
That's a very good question, Adam, but the reply to that is yes and no, to be completely honest. I have a shared case where I think social media is liable, and now I'll share another that is not liable. So the next case that I'll be going through is Doe versus MySpace. The operators of MySpace.com are not liable for underage girls who were sexually assaulted by men they met on the popular social networking site in MySpace. A California appeals court has decided upholding a lower court's ruling. According to the lawsuit, the 4 girls were lured from their homes via MySpace by men in their 20s who sexually assaulted them. MySpace was not held liable as the speaker of communications between the victims and their assailants under the Communications Decency Act 47, USC subsection 230, the panel said. The 4 unidentified girls sued MySpace in the Los Angeles County Superior Court. They alleged negligence, gross negligence, and strict product liability. In this case, the judge felt that MySpace was merely a platform and did not take part of any communications between the 4 girls and the sexual predators.
I see. Shaun, thank you so much for
Oh yeah,
answering
no worries,
all my
no
questions.
worries. I hope I
Looking
answered.
forward to see you soon.
Alright, thank you.
Take care.
Hey, take care, man. Cheers, cheers. This brings me to my conclusion of how relevant is this topic in today's society. Based on an article published by the New Straits Times Malaysia, out of 184 cases involving planned attacks on children last year, WeChat was most used with 138 cases, Facebook with a second of 35, WhatsApp with 6, and BTalk with 5 cases. Federal Police Sexuals, Women and Children Investigation Principal Assistant Director Commissioner Ong Chin Lan said 184 child rape cases related to social media apps were reported this year. There's an increasing number of users of social media, with more kids learning how to use technology every year. Keeps on going on and on, with more kids getting more advanced. If this issue is not taken more seriously, the magnitude of negligence will become bigger.
What's the password? Pull out game.
Hi, what do you need?
I nak abortion.
Okay, let me take a check. Whoa, looks like we got a messy situation. Okay, I've checked the situation and you take these pills and come back in a week.
Bang, I nak sekarang. Cepat.
Okay, that might be risky, but I can try.
Boleh?
The scenario presented before you portray a mother aborting her child in a shady and clearly illegal abortion clinic. The mother, a healthy 25-year-old woman, opted for an abortion, wanting to free herself from any responsibility that comes with motherhood. Unbeknownst to the husband, the mother went ahead with the operation and aborted her baby. A sad and perplexing legal quandary long has existed when someone's negligence causes the death of an unborn baby. Whether the fetus dies in a car accident, through medical malpractice, or some other negligence, the issue of whether the family can file a wrongful death suit has been hotly debated. The issue is a particularly sensitive one because it deals with the controversial question of when life begins. Since wrongful death claims only apply to persons, the question is whether a fetus falls as a person. As a general rule, abortion is illegal in Malaysia, and both parties, the mother and the provider of the service, can be charged according to the penal code. Exception to this is for the medical cause in which a registered doctor formed in good faith that the continuance of the pregnancy would involve risk to the life of the pregnant woman, or injury to the mental or physical health of the pregnant woman greater than if the pregnancy were terminated. Apart from this cause, it remains illegal. According to an article published in the New Law Journal, Over the Limit, a fetus only obtains a legal identity at its birth. In the duration of the formation of the embryo to its pending birth, there are very few statutes in place that clearly depicts the law surrounding them. In S.V. St. George NHS Trust in 1998, it was held a fetus has interests which are protected by the law. Following 2004, in v. France, a fetus is not directly protected by the European Convention on Human Rights. Continuing onwards, we will now dive into duty of care, specifically duty of care owed to fetuses, or in layman terms, unborn babies. Those who advocate new fetal rights are vigorously opposed by those who believe that any such rights would infringe upon the fundamental rights of pregnant women and in the bargain do more to harm than to prevent injury to the unborn. Albeit unclear, There exist laws within both the English legal system and Malaysia that are in place to ensure an unborn child is given a sufficient, granted not adequate, chance at life. However, there is a dire need for the Parliament in both nations to further amend the aforementioned statutes to put the lives of the unborn on the same pedestal that we are placed on. Blurred lines and ambiguous words leave room for connections and creative judgment, yes, but it also voids this life of their rights. Oftentimes, we are left to the judge's discretion and past judgment made in the higher courts to fill in the lacuna, to make connections from the laws that safeguard the rights of us, a person, and ensure the same is applied to those yet to be born. The relevance of such a topic in the tort of negligence today is depicted in the sheer number of cases that are reported in both the UK and Malaysia. In summary, it appears that the fetus is recognized to have interests in English law, but it is not equivalent to a person. As such, when a person's interests conflict with those of the fetus, it is reasonable to assume the interests of the person will be upheld. As it is not a person, it does not have a direct right to life. Even if it were a person, and under the English law it is not, the interests of the mother could still reasonably be taken to have precedence. This is Amir. Thank you.
Now, we will move on to another topic which is known as psychiatric injury. The question is, what is psychiatric injury? Firstly, psychiatric injury is also known as nervous shock, and it is an psychiatric illness suffered by one party due to the negligence by another party. There will be two categories of victim, which is known as primary and secondary victim. The distinction between primary and secondary victim is that those who are involved in accidents are primary victims, and those who only suffer from what they see and hear are secondary victim, as stated by Lord Lloyd in Page v. Smith. In order to claim for psychiatric injury, the victim has to prove three elements, which are forcibility, proximity, and immediate aftermath, which are established in Alcock v. Chief Constable of Yorkshire. However, medical evidence should be provided to prove that psychiatric injury is valid rather than just mental distress, as stated by Lord Bridge in the case of McLaughlin v. O'Brien.
Hi boss, where are you now? Okay. I'm at the construction site now. I'll be there in about 2 minutes. No, I need to bring this. I need to bring this to my boss. I want nobody but you.
I want nobody but you. I want nobody. I don't want nobody.
Oi, what do you want? You asked me to bring this paper to
When I asked you to bring...
Boss, on the way here I got hit by something.
Wait.
Can I claim for personal injury? I want to claim for.
You think I'm your bank? You want to claim?
I want to claim some money. Boss, really pain my head.
You not careful. You want to claim from me? You take this. You pass. Stop. You take this. You pass to Amir. You get up.
B is A's brother who share a direct relationship to him, and B actually suffered post-traumatic stress disorder after seeing his brother commit suicide. The question is, can B claim as primary victim?
Oh my god! Hey, are you alive? Can you help him? Can you help him? No. Please! He's dead, there's no help. Help him! Please!
Here, C is just a normal person who passed by but actually tried to save A. Can he be established as a rescuer? D has just passed by in the same time, suffered post-traumatic stress disorder, and D established as a bystander, and can he claim?
For the first question, the Law Commission Psychiatric Illness Report stated that an employer
employer has a duty of care to an employee not to expose them to the risk of physical injury and psychiatric illness. However, it can be argued that an employer is not liable in all circumstances for all psychiatric illness suffered by an employee who carried out their employment duties. The employees must show that they were directly involved in the course of their employment, and the employment duties brought them within the area of risk of physical or psychiatric injury. In this case, A's depressive disorder developed because his injury happens in the area of his employment duties, and the employer should have aware of it when being told. For the issue in the second question, we can look into the case of car versus IBC vehicles. The employer would be liable because he has owed a duty of care to claimant, and the claimant would not have committed suicide if he had not been injured. B is classified as primary victim as he has direct relationship with A and able to claim damages from A's employer. For the third issue, C would not be able to claim as primary victim. But why? Because rescuers were not considered as a special category of secondary victim, but had to be subject to the normal rules as stated in Alcock vs. Chief Constable of Yorkshire. So, we can conclude that C is able to claim for damages. In the final issue, D was a bystander which only passed by but actually witnessed the incident. Case of Borhill vs. Young has established that ordinary bystander could be expected to withstand the shock as both parties doesn't have direct relationship. Hence, D will not be able to recover any form of damages from the employer. To summarize, we can say that psychiatric injury are still relevant until today as the popular interest in this area of law has been heightened by the widespread media coverage that has been given to high-profile cases such as in Hillsborough Football Stadium. At this stage, legislation curing defects in the present law is appropriate. The law should otherwise be allowed to develop by judicial decision-making.
So, is the tort of negligence still remain relevant in the light of changing social circumstances? With regards to the area of law controlling the social media, it is suggested that the tort of negligence still remain relevant as cases are solved using the current set of legal tools. However, it is notable that the cases of violation of social media is still increasing in Malaysia. This can be explained with the fact that there's no any standing decision regarding such area of law and that we are still in the midst of empowering our law. With regards to psychiatric injury, a change in the point of law referring to Borhill and Young, where only forcibility of the damage is required in establishing psychiatric injury. However, the law now requires the three elements in satisfying such claim, as in Alcock and Chief Constable. It sufficiently satisfies the primary aim of the law of tort, which is compensating the aggrieved parties with compensations. Then it is also relevant to conclude that the Malaysian position of law equally protects the mother and her fetus. However, the UK point of law prioritizes the mother during the pregnancy. It is suggested that we are not in a position to conclude which country of law stands more superior than the other, because the locality, culture and educational development of the people have to be taken into consideration. Furthermore, the stance of UK in the subject of disputes arising between e-hailing company and the passenger is that there is no employer-employee relationship established between them. However, in Malaysia, there is no decision made regarding this point of law yet. But if you stretch out the interpretation of the laws, there should be an employer and employee relationship established between them. Despite of the blurry area of law, the insurance is still taking the responsibility of compensating the aggrieved party. As a whole, a fine conclusion can be drawn of which the tort of negligence still remains relevant by being able to remedy the injured party and act as a deterrent to other people subsequently. Right now, I would like to thank all of my teammates, and of course our beloved lecturers who is watching this video. Please shout out to Goh Wen Wei, who is in psychiatric injury. Yeah. And innovations in social media being presented by the Shaun Foong. Yeah, and of course, Amir, who has presented the abortion. And
Last but not least,
last but not least, Adam, who has presented the e-hailing company area of law. Thank you guys, thank you.
The one who survives will be the winner.